Hello everyone, and welcome to Uncivil Law. For today's case, we have John Doe, 8 through 10, versus Rick Snyder, the former governor of Michigan, and various administrators of prisons, wardens in the state of Michigan. In this case, John Does are prisoners, and they're accusing the government of not giving them due process when it occurs to reporting sexual assaults that occurred inside the prison. They're saying that they were denied due process and forced to undergo labyrinthine procedures that were designed to discourage them or prevent them from filing their complaints, and so they're bringing suit for violation of their rights in that respect. So we're going to read the case and see what it has to say. The Prison Litigation Reform Act requires inmates to exhaust available administrative remedies. The Supreme Court has explained that the Litigation Act contains its own textual exception to this mandatory exhaustion. Under the statute, exhaustion requirement hinges on the availability of administrative remedies. An inmate, that is, must exhaust all remedies, but need not exhaust unavailable ones. The question here is where the administrative remedies provided to inmates by the state of Michigan are available. In the case before us, they are not. As the experience of John Doe 8 and John Doe 10 show, the Michigan Department of Corrections administrative process is in practice filled with contradictions, so much so that we hold it as unavailable. The plaintiffs, John Does 8 through 10, are inmates in various Michigan prison facilities. At one time, the Does were juveniles housed with adult inmates, a policy that Michigan has since abandoned. The plaintiffs bring 1983 claims that stem from alleged sexual abuse by adult inmates, which occurred when the policy of housing juveniles with adults was in place. So here the allegation is that juveniles were being kept with adults in adult prison, and as a result they were being exploited, and they want to bring a complaint for not protecting them. Now, while the state in general has no affirmative duty to protect people in general, they do actually have an affirmative duty when it comes to prisoners because they cannot protect themselves. So the state does have an affirmative duty to protect prisoners, and if they're being maltreated, then they can be liable for that. So let's read on. The Department of Corrections adopted a grievance procedure pursuant to the Prison Rape Elimination Act. The Prison Rape Elimination Act generally left intact the Litigation Reforms Act exhaustion requirement, but regulations promulgated pursuant to the Prison Rape Elimination Act modified one aspect of the exhaustion. The Department of Justice issued a final rule mandating that an agency shall not impose a time limit on when an inmate may submit a grievance for allegations of sexual abuse. In order to understand whether due process was given or not, we need to understand more about Michigan's process, both in general and as it applied to these particular inmates, so let's read a little bit more. In 2016, Michigan instituted a two-step Prison Rape Elimination Act grievance process for sexual abuse claims. At step 1, an inmate must submit a grievance form to the coordinator or an inspector at the facility in which an inmate is housed. Then, an inmate may only file a step 2 administrative appeal to the administrator if they're dissatisfied with the response received at step 1 or they did not receive a timely response. So here there's ostensibly a two-step process. First step is make an initial report to an initial administrator, give them a chance to cure, and if you're not satisfied, then you can appeal. And presumably you could then go to court after that, after you've exhausted your administrative remedies, but you give the prison a chance to correct the problem first. With that background in mind, we turn to the experiences at hand. In 2016, Doe 8 filed a grievance based on a rape and sexual harassment that he experienced while in prison. After that, Doe 8 received from the Department of Corrections a memo that stated his complaint would be treated as a Prison Rape Elimination Act grievance. On June 13th, Doe 8 received a response from the coordinator. The response stated that his Prison Rape Elimination Act grievance has been received and reviewed, that he be notified of the outcome of the investigation at the conclusion of the investigation, but also, although the investigation is pending, the grievance is considered responded to and closed. If you're having a difficult time figuring that out, so am I. It's both pending and closed at the same time. Magic. Doe 8 was unsure about what the response meant. In the absence of any, indication from the Department of Corrections as to which of the two contradictory statements in the response were true, Doe the 8th nonetheless filed a handwritten Step 2 appeal on June the 7th, 2016, after he requested a Step 2 form but received no response. At oral argument, counsel for the state represented to the court that July 18th investigative findings and actions form is neither a Step 1 nor Step 2 document. Rather, it's the termination of the process. Yet also at oral argument, counsel for the state responded that Sergeant Bellinger would have been one of the investigators, and counsel did not think that he was an administrator. So even at the appeal, the counsel for the government is unable to clarify exactly what the status of this thing is. They're not able to clarify what's going on. And they're saying the person who's investigator is not an administrator for this purpose, so they're not handling it the way it should be handled. Doe 10 filed a grievance based on sex abuse and harassment that he experienced at various Department of Corrections facilities. On June 8th, 2016, Doe 10 received a memo stating that his complaint would be processed as a Prison Rape Elimination Act grievance. Doe waited for a response but never received one. Accordingly, Doe received a grievance appeal form sometime in early July, but Doe claims he never actually received any form. Accordingly, Doe requested a grievance appeal form sometime in early July, but claims he never received any form. So it looks like the state wants to have its cake and eat it too. You know, they don't want to process the forms. They're putting up all these road barriers and blocks. They're not giving a fair process. So what does the Court of Appeals have to say? Looking at this record, the state's administration of the Prison Rape Elimination Act's grievance process is a classic case of Orwellian doublethink that falls comfortably within circumstances outlined in Ross v. Blake. Examples of such contradictory statements abound in the record, and inmates need not navigate this labyrinth world of doublethink to satisfy the exhaustion requirement. The examples show in practice no ordinary prisoner could discern or navigate the process, and the process was designed to trip up all but the most skillful prisoners. The Department of Corrections stated the investigation of a grievance is pending, and an inmate will be notified of the outcome at the conclusion, while simultaneously stating that the grievance is responded to and closed. In the defendant's view, the grievance is both pending and closed, and that makes no sense. A prison official inaccurately described the process to Doe. The department regulations require an inmate to appeal the Step 1 decision to an administrator in a central office. Doe 10's grievance coordinator, however, attempted to appeal and told Doe to send it to the SRF, not to the central office, and gave Doe the wrong information. The investigative findings and action forms is a Prison Rape Elimination Action form, yet it is neither a Step 1 nor Step 2 document. That form is apparently the termination of the investigation into the grievance, but again, it's not a Step 1 response that can be appealed, and this confounds the confusion. Clearly, the Michigan Department of Corrections Prison Rape Elimination Act grievance process is, in practice, filled with contradictions and machinations, and these contradictions and machinations render the process incapable of use. So that is the end of the case of John Doe's 8 through 10 versus Rick Snyder, former governor, and various prison wardens. In this case, we learned that the state of Michigan had a labyrinthine Orwellian process, in the words of the Court of Appeals, in order to file complaints under the Prison Rape Elimination Act, an act that was designed specifically to deal with this. And they had all these problems and misinformation and were denying people and telling investigations were both open and closed and so forth and so on. So when they went to court and argued about this, the initial response from the government was they didn't exhaust their administrative appeals. They have to exhaust their administrative appeals. But the Court of Appeals says they don't have to exhaust administrative appeals that don't actually exist. You guys made it so impossible to comply with these rules in any meaningful way that they don't really exist. So you can't force them to comply with stuff that is impossible to comply with. And as a result, you can go to court and seek further action. So this will go to court and seek further action for redress for these alleged violations. And that is the end of this case.